Why don't we do that? Just because we're waiting for one of the jurors to come back and get the particular juror. You do that. So I'll meet you. Our last one.
Sir? Yeah, please. No problem. I wear them all the time too and forget.
Trash can?
right under the table. Right here on this,
This one.
yeah.
Thank you, sir.
Yep.
She gets on her loop.
Oh, yeah, I bring my own lunch. Dave, are you guys about ready?
What's that?
You good? Set up?
Good. Everybody here? So weird. I hate hearing my voice. Who did that?
just wanted to make sure you guys were ready before I let him in.
I appreciate that. So you said that's been how long since you've been hunting?
Well, my son's 37, so 20 years.
Oh, why'd you stop?
Lost interest.
I'm
It's
kind of
just I was not getting any animals I was liking. So it was just hard to go out there and spend all that money and not get anything at all.
it's kind of the same way. I was doing it with my father-in-law. He's got Parkinson's. And so he's retired first sergeant army. He didn't get to go out with me because he was getting sicker.
Find it.
That's right. If I don't need a meat and treat, I'm not gonna get them.
Right.
get
And I wasn't trophy hunting. I was just looking for something worth killing, you know. So.
It's bad back from where actually without you 12-year lease. Wow. A lot of them are killing and cutting their heads off and those.
Mr. Miller,
Yes,
ready to go?
yes.
Okay. Ready to go?
Now, not for the jury.
No. Judge.
Yes.
All right, please.
Thank you. Please be seated. All right. Okay. Let's go ahead and go back on the record. We are in session in the matter of Mast v. Brashier, Nez Perce County CV 35-23-195. The parties and counsel for the plaintiffs are present. Mr. Brashier, Ms. Brashier Mast, the defendants are also present. We are outside the presence of the jury at this time. Mr. Miller, you mentioned a moment ago that you had one other item to take up before we return the jury.
Thank you, Judge. Yes, as we were, Mr. Hickey and I were preparing for our next witness over the lunch hour, discussing her testimony, something came up that I want to address before we get there, before anything gets blurted out in front of the jury. So I'll address that however we can. But one of the exhibits that the defendants wanted to introduce at this trial was an alleged police report from Lewiston Police.
That was Exhibit G, if I'm not mistaken.
I think so.
Proposed Exhibit G.
Proposed Exhibit G from a report allegedly from Nick Eiler. Is that
correct?
Okay.
That's my recollection.
That has been disallowed, will not be admitted into evidence. Our witness that's coming next, Detective Danielle Hendricks from North Dakota, is not going to talk about the details of that report, just to make everyone aware. She's not going to get into that. But we are concerned that as she testifies the way she's going to, that may trigger the defendants on cross to want to get into the details of that report, which has not been allowed. So we do not plan on opening the door to it.
Okay.
We do not want anything blurted out about the contents of that report or even its existence, frankly. And having that, being unable to unring the bell after that.
And again, I note, just for purposes of the record, the report in question refers that I think Detective Eiler had received a phone call from Sergeant Hendricks, who had asked him to do some interviews, and that's really her involvement in that report, and everything else was action taken by Detective Eiler and the Lewiston PD. Is that
Yes.
fair?
And,
Recap of
and
that.
even to make an offer of proof, Judge, if I need to, Detective Hendricks will testify to that she asked that a forensic interview be done in Idaho. Received that information, that data. She then acted in a certain way after that. She'll testify about steps that she took following that, but she's not going to talk about the contents or even mention his name. That's correct. That's right.
Mr. Brashier, Ms. Brashier, anything that you want to say on that?
Yes, Your Honor. I believe I should be able to have a defense against that and be able to ask questions related to a forensic which she ordered.
Well, okay. I guess my response to that would be, she is not the person I understand that conducted the forensic interview. Is that correct?
That's correct, Judge.
That is correct.
All right. So I don't know that she would have any firsthand knowledge of the interview other than having received information regarding the interview.
Am I able to ask if she ordered it though and what the results of that order were?
It sounds to me like that may come out on direct. I don't know. Is that something that?
Judge, Detective Hendricks is going to testify that she received this information from Detective Eiler, and then she took certain steps after that.
I think that to a certain degree is opening the door. That's a fair question on cross, which would be, did you ask Detective Eiler to do this?
Yes,
And
that's fair.
And what did you receive? Which I suspect may come out on direct if I'm hearing right, because that's gonna frame the basis of her actions in accordance with that information received. Am I misreading that?
Well, maybe. I think our concern is that, and we know that Ms. Brashier Mast has attempted to have the court have this exhibit admitted twice, right? We know that she's very interested in having the results and the allegations that are in this report be made public. That's the hearsay that should not be allowed. I think that we anticipate that on cross-examination, she's going to ask, the question we can anticipate, Judge, to be totally clear with the court, we're anticipating a question along the lines of, isn't it true that in that report, my kids disclosed sexual abuse? That should not come out. That's hearsay within hearsay, and that's been disallowed by the court already in that report.
And I agree with that.
Yeah.
I do agree with that.
Your Honor, if I may,
You may.
am I entitled to ask what the results of the report were?
And I think that's going to depend on whether the door is open to that is, I think, dependent on what happens during direct examination. And let's just maybe go down that. Mr. Miller, do you intend to ask her?
Can I step aside and let Mr. Hickey take over?
Yeah,
He's going
please
to
do.
question the witness, so.
Please do. Mr. Hickey, I'm happy to hear, and I appreciate you bringing this to my attention now. I think this is going to save us some time in the future. So, Mr. Hickey, help me understand where we're going with this. I'm assuming we're going to hear Sergeant Hendricks talk about contacting LPD.
That is correct.
And asking LPD to do some investigation.
To do forensic interviews, yes.
Okay.
A forensic interview.
And what do you intend to do with that information? How is that?
That information was then sent to her, and what she's not going to testify about the substance of it, but she's going to say, I reviewed it, and then I reviewed the actual forensic interview, and then I decided we're doing a forensic interview here in North Dakota.
Okay, so she.
And that's it.
And that's it, okay. I think I'm envisioning the question on cross being something along the lines of, were there concerns raised in this interview from LPD?
Well, I think then you are getting into hearsay.
Our concern, Judge, is that she's going to go even further and say, isn't it true, aren't you aware that my kids disclosed sexual abuse in that forensic interview?
Right, and we're not getting into any of the results or anything, just what her next step was after she reviewed that information.
And if I was to make those results, those declarations, then they would have the right to object. However, I plan to keep my questioning very simple and directly to the point of For example, what were the results of the interview?
I think it's one thing to say, what are the results of the interview? And that's where we're getting into potential hearsay within hearsay. It's another thing to say, did that interview raise concerns?
I could say what did the
Is that
interview raise concerns?
Or,
I think that would be appropriate. I think that would be fine, Judge, if it's limited to that.
right,
I don't want the bell to get rung that we can't unring later, that she says that there's a report out there with abuse allegations
Can-
that is not admitted.
Can I ask if the forensic was positive for sexual abuse?
No.
well, I'm not gonna allow that, but I'm certainly would allow you to ask, did that report raise concerns? Without getting into the contents of that
Yes.
report, did it raise concerns? And then she can articulate whatever it is that she's going to
Okay,
articulate at that point.
Absolutely.
Does that make sense?
Yes, absolutely.
But
Yeah.
and let me ask, Mr. Miller, Mr. Hickey, is that satisfactory to the,
Believe so.
okay, and you're comfortable
Okay,
with that?
yes, I'm comfortable with that.
Okay, then we'll plan to do that.
Right.
Anything else that we take up? All right, let's, and then you've got, Mr. Hickey, sounds like you've got your witness ready, is that correct?
I'm sorry,
Your witness is ready to go as soon as we return the jury?
She is, Judge.
And then I will, pursuant to our conversation in the other room, when the jury comes back, I'm gonna let them know that nobody's trying to be rude by, I'm gonna use the term ignoring them. That's a harsh term for what I think is, we're being cautious, but you're doing that on my order. So I'll let them know, just so that, nobody feels like they're getting slighted by either the defendants or the plaintiffs. Okay?
Thank you, Judge.
All right, please rise for the jury. Be seated. All right. The record will reflect the jury is back. They appear to be all here, if I'm doing my math correctly. Do the parties agree and stipulate that the jury has been returned and are appropriately seated at this time?
Yes, Your Honor.
Mr. Brashier, Ms. Brashier, Mast, any problems with how the jury's seated, or do you agree that they're returned and seated properly?
Yes, Your Honor.
Thank you. All right. Ladies and gentlemen, welcome back. I should have made this announcement earlier and I didn't, and for that I apologize. We're in a relatively small area, and so on breaks such as lunch and when we're leaving and coming to the courtroom, on occasion, you may run into the parties or you may run into their attorneys. If they don't talk to you, I promise you they're not trying to be rude. The reason they're not doing that is because I've ordered them not to, because I don't want them messing with my jurors. Really is what it comes down to. So, and I should have brought that to your attention because sometimes, I don't know, you may be in a situation, again, we're in very close contact. It's just the nature of our building. And they may turn the other direction, they may look down or, please don't feel slighted. I just want you to know that they're following my orders to not have any, or I shouldn't say not have any contact, but have as little contact as possible outside the courtroom. So I appreciate that. I meant to do that yesterday. I failed to do that, and we've had some contact. I understand that we've had to talk a little bit about that, and so it occurred to me that I owe you an apology for not sharing that with you. So there we are. So they're doing it on my order. So thank you for your understanding in advance. With that, Mr. Hickey, I'll let you call your next witness.
Thank you, Your Honor. Danielle Hendricks.
Is it detective? Sergeant, if you please face my clerk and be sworn.
Do you affirm under the penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
All right. Sergeant, if you'll take a seat, make yourself comfortable. And I'm sharing this with everybody. This is a brand new courthouse, and so we're learning about the acoustics.
Okay.
And so one of the things that we've learned is sometimes it's hard to hear the witness, so I'm going to ask you to speak up.
Okay.
And we're going to test that by having you state and spell your name for the record.
My name is Danielle Hendricks, and it is Danielle. Hendricks is Hendricks.
And ladies and gentlemen, are you able to hear Sergeant Hendrick fine? All right, thank you. Mr. Hickey, you may inquire.
Thank you, Your Honor. I think I heard you say as you were walking up, you're a sergeant.
Yes, I am.
And how long have you been a sergeant?
Since approximately 2018.
And you are with the Williston Police Department in North Dakota.
Yes, I am.
Why are you here today?
I'm here today because I worked some investigations back in 2018, 2019, but most importantly because an innocent man lost his life.
And you're talking about John Mast?
Yes, I
How
am.
did you get here today?
I drove.
From Williston?
Yes.
13 hours?
It was about 14 and a half.
Did you try to get flights here instead of driving?
I did.
And?
Where I live at, it's also very remote. And so the flight schedule would have ended up being like 17 and a half hours with layovers and then getting to Spokane, which was like the closest I could get a reasonable flight into. I was like, I'll just drive it.
So this was very important to you?
Very, yes.
How long have you been in law enforcement?
I started my career in 2012 with the Wilson Police Department.
And in what capacity did you start there?
So I began as a civilian in 2012 as a 911 dispatcher. My chief at the time came to me and said, I want you to go to the academy. I told him he was crazy. I wasn't going to be a cop. I had no desires to. And he goes, oh, no, you're going to go. And I was like, okay, I guess I don't have a choice. So I went to the academy, became a patrol officer once I received my post certification. And I was a patrol officer about a year and a half. And then pretty much immediately, my chief moved me into investigations.
Okay, so how long have you been an investigator at this point?
Approximately 10 years now.
How many investigations would you say you've conducted?
If I had to take a guess, at the beginning of my career, I would average around 300 to 350 cases a year. My numbers have dwindled down a little bit over the last few years just with my extra duties that I have, but I would say thousands at this point.
Have you had any occasion to do any child abuse investigations?
Yes, so that's actually what I specialize in is all of our kid cases. So I do all of our child homicides, child rapes, child abuse cases. That is my specialty, and that is what I do is basically any crimes that involve children.
Do you feel, are you any kind of a child advocate?
Huge child advocate.
And why do you say that?
Children are they're our future. That's our next generation of leaders, and they deserve to be protected. I also sit on the so it's the sexual assault response team. I'm the law enforcement representative for that, specializing in
Have you developed a little bit of a reputation for your investigations regarding child abuse allegations?
My chief introduces me as if somebody hurts a kid in our town, this is the one that's going to figure it out.
Have you received any special training in child abuse, sexual abuse allegations?
Yes. Over my course of investigations, I have attended the Dallas Crimes Against Children Conference twice, received hundreds of hours of training specializing in child abuse, child sex crimes, child homicide. Also, there's been some courses on the psychology of deviant perpetrators. I've been to conducting unexplained death in children investigations, homicide investigations trainings. I've had extensive interview interrogation trainings. I also have had a lot of training in child death, specifically too, but I serve on a state child review fatality team for the state of North Dakota. So not only do I investigate our child death cases, but I am the law enforcement rep for the entire state of North Dakota. So I review every death that occurs with a child in my state. And I will kick those cases back to law enforcement if the law enforcement agencies, if there's things that maybe they missed. I also am the human trafficking law enforcement representative for my area and region as well for the state. So I also specialize in human trafficking with children specifically. I am a child abduction response team commander. So if we were to have a child abduction, I would be commanding of those situations. I'm also a child abuse, child sex crimes instructor. So I not only teach at the academy, I teach all new law enforcement, child abuse and child sex crimes. I'm also the vice president of the Family Crisis Shelter, which is for domestic violence. And then I also teach at the academy to all new recruits. I don't know, that was a lot, I'm sorry.
Well, you've got to answer the question, so we appreciate that.
Yeah.
I know you deal with child abuse investigations. I want to get a little more specific. Do you ever investigate sexual abuse, child abuse?
Yes, yes.
And when you get allegations of sexual abuse of children, what type of priority do those get?
They take probably top priority. I mean, any crime with a child is very important, but a sexual exploitation of a child it's a whole different beast, and there's a lot of concerns there.
Do you know how many child sexual abuse cases that you've investigated in your career, approximately?
If I had to estimate, it would be well over 1,000.
How did you become familiar with John Mast?
I was assigned to investigate a report that was filed with my department in approximately February of 2018.
And do you know who prepared that report?
So the report came to me from social services. There was a 960 filed, and to explain, I apologize, I don't know what Idaho has. 960 is our North Dakota state mandated suspected child abuse or neglect report form. So that is what is required by state law to be sent when there's any suspected child abuse or neglect. So I had received a 960 and the 960 report information came from Rebecca Mast.
Okay, and that's a one-page form, correct?
It is a one-page form. However, I've received, I believe, 8 or 9 pages.
From Rebecca Mast?
On the 960, yes.
Was that unusual?
I had never seen something like that, no.
Was it just a narrative, or what? Was it attached, or what?
Yep, so, and let me clarify so I don't confuse anybody. So the 960 comes in, the top portion of the form is the child's name, the child's date of birth, who the parents are, who the caretakers are, and then who is the subject that is abusing the child. There's the middle portion of the form, which is the narrative, which is where you fill in the suspected child abuse and neglect. And then the bottom form is the reporter's information. And then there's another category where they categorize the concern as a level A, B, or C. And that's kind of social services way of issuing a priority of the allegations that are being reported. So in this specific case, the narrative form was completely filled out, and then there was an additional 8 or 9 pages handwritten with concerns.
In reviewing that information, did you start to think there might have been a child custody case going on?
It was very apparent to me throughout the data, once I received and read that report, that there had to have been some sort of a custody situation going on, yes.
Did you take the allegations any less seriously because there was a custody case going on?
Not at all.
So just like any other intake that you get on something like this, you took these allegations just as seriously as any other?
Absolutely.
What did you do to begin your investigation?
So the first step for me as law enforcement, when I get a child sexual allegation or report, child safety is the most important step that I have to take, right? Is the perpetrator in the home? Does this perpetrator have access to this child? I had established in this investigation that the children were currently out of state with the mother, which would have been a non-suspect abuser. And I knew that the alleged abuser, John Mast, was currently residing in Williston, so I knew that the children were safe. So I had reached out to an agency in Idaho and requested a forensic interview for the children.
And that was conducted in Idaho around February or March of 2018.
That's correct.
And that information was sent to you?
Yes.
And did you review it?
Yes, I did.
What did you think about the information you received?
I had some concerns, which led me to review the actual interview itself, which was video recorded.
Okay. After you watched the video of the forensic interview, that's of a child?
Yes, correct.
What did you do after that, after you viewed that?
There was a point during my investigation where I had set up an interview with John Mast.
Did you, because of after viewing the forensic interview in Idaho, did you then order a forensic interview in North Dakota?
Later on, yes, I did.
That was around September of 2018?
Yes, correct.
And where was that conducted?
It was conducted in Minot, North Dakota at the Children's Advocacy Center.
Okay. 1 second, Your Honor.
You may.
If I may. Did you review the results of that forensic interview in Minot, North Dakota?
Yes, I did.
And what were your thoughts after reviewing that?
Neither of the children disclosed any sexual abuse or physical abuse from their father, John Mast.
Ms. Brashier.
Hearsay.
Your Honor, it's no disclosures.
We do not have the forensic here to go over that.
Your Honor, this was part of her investigation and the steps she was taking, and I asked her thoughts on what she observed from the forensic interview. It's the effect on the listener, which is her, and the actions that she then took.
Given that I do believe its effect on the listener, I am going to find that's an exception to the hearsay, and I'm going to overrule the objection at this time.
Thank you, Your Honor. So, at some point, and I think you testified to this a minute ago, did you interview John Mast?
Yes, I did.
Was he cooperative?
John was more than cooperative throughout my entire investigation. He actually stayed in constant communication with me from probably the very beginning. He would email me, he would call me, and he basically would keep me up to date on anything like, hey, I might have to go out of town for this if you need me. Basically kind of any answers and making himself 100% available if I needed him for anything.
And I want to ask you about the length of this investigation. So you opened your case approximately February or March of 2018?
That is correct.
And it did not close until August or so of 2019, is that correct?
I believe, yep, the initial reports came in February of 2018, and we finally closed all of, and I don't know if I hit on this. This was drawn out, and there was multiple complaints received, additional information constantly coming in, which is why this investigation was lengthy. And I believe we ended up finally closing everything in August of 2019.
Okay, so you had this, for lack of a better phrase, in your hands, overseeing it for a year and a half almost.
Well, that sounds about right, yes.
You just mentioned John Mast being cooperative with you. I'm assuming that's something when you're investigating someone like this, especially with these kinds of allegations, are you taking in all kinds of information as far as their demeanor, looking at them? Are they cooperating with you? I mean, is that important to you?
Yes, it's definitely something I make note of, because most people don't like to talk to law enforcement. We're the bad guys, or, maybe some people just don't want to talk to us because they're afraid that we might catch on to something. That absolutely was not the case in this. I remember making a notation, and there was times where I would be busy and I wouldn't be able to get back to John, and so he'd send me another email. Hey, just making sure you got my last email. He was very, very communicative, and it was very noted. Like, I remember specifically being like, okay, yep, I'll get to you in just a minute. Hold on.
So you talked about allegations. Were there continuing to be allegations throughout this year and a half? Is that what you were saying?
Yes, it was.
Who were they coming from?
Rebecca and her family, and then also information would come in from third parties, so maybe like a therapist or a counselor who are mandated reporters. They would be then sending us documentation or reports of additional data, maybe some additional information that the children are talking about. So it was constantly, additional data was coming in throughout that entire year and a half.
Was that frustrating for you?
It was just very aggressive, and it did frustrate me. And I can talk a little bit more about this in a little bit, because I remember throughout this entire investigation being like, what am I missing? These allegations were so aggressive and they were so in my face that I was like, I felt like I was missing something. And obviously I'm a huge child protection advocate, and I never want to drop the ball on a kid or children. And I remember talking with my chief. I remember talking with some of my coworkers, and I was just like, hey, can somebody else look at this? Like, I felt like I was just spinning my wheels. Like, am I missing something?
Because you weren't seeing anything.
Correct.
Did at some point you ask John Mast to take a polygraph?
Yes, and to clarify, I don't remember if he offered or if I requested him to do one. But yes, a polygraph was conducted of Mr. Mast.
Okay, well, that's fair. But either way, when it was brought up, he didn't hesitate to take it.
Didn't even question it.
Do you normally do polygraphs?
No.
Why not?
I think in my entire career, I've maybe done 3 polygraphs.
Out of all the thousands?
Yeah.
Only 3? Yeah,
and I think if my memory serves me well, John was the last polygraph that I have ever requested.
Okay, why is that?
I'm pretty good at talking to people, and I've got enough training and enough experience. I'm pretty good with the totality of the circumstances, whether it's collecting physical evidence, conducting interviews. I'm really good at getting people to talk to me. Very successful confession rate.
How successful?
Approximately 90 to 95%.
So then polygraph's not even needed?
No.
Was part of the reason you asked or came across doing a polygraph here because of all these allegations?
Yes. And
you were questioning yourself.
Correct. And I want to clarify, the polygraph was requested after my interview with John. And once that interview was done, I was still, there is nothing here. And these allegations were just so aggressive and so in my face that I just truly felt like I was missing something. I didn't want to be the one to drop the ball. And so I was like, okay, let's do this polygraph.
And you knew the person that did the polygraph?
Yes, Steve Gutnick, he is currently now my chief of police. However, at the time he did the polygraph, he was a special supervisory agent with the North Dakota Bureau of Criminal Investigations.
And what were the results?
He passed. No deceit shown.
Barely passed, almost passed, what?
No, in fact, Steve Gutnick pulled me aside after the polygraph was completed and told me that he gave zero indications of deceit. Body language, anything on the machine, nothing.
And he was being questioned about sexual abuse allegations of his children.
Yes.
So at that point, did you feel that criminal charges needed to be filed against John Mast?
I didn't have probable cause.
Was it at that point or before that you started running the case and the investigation by other people in your office, bouncing ideas off of them?
I remember talking to quite a few different people throughout the course of the entire investigation, but once the polygraph was conducted, yeah, I mean, it was just, I didn't have anything.
And did you have anyone else review the case?
Yes, so obviously, just to kind of explain, when I say probable cause, what I mean by that is more than likely a crime was committed. And so in cases, and specifically in this case, I just wanted that extra reassurance, just because, like I said, these allegations were very aggressive. And I wanted to make sure that from a lawyer's perspective, they felt the same way. I sent this entire case file to the Williams County State's Attorney's Office, which is, I think you guys do DAs here, so maybe the equivalent of district attorneys. I sent this entire case file to the State's Attorney's Office. They reviewed it and completely agreed with my findings, and in fact gave me a no charges memo for the entire case file.
You mentioned probable cause. What is probable cause?
Simple terms, probable cause. If you want to put it in a percentage, it's 51%. So I believe 51% you committed a crime.
So you didn't even have 51%.
No.
10%?
I had 0%.
On John Mast's case?
Correct.
Do you ever work with psychosexual assessments in your investigations?
Yes, I do.
What is that?
A psychosexual evaluation is basically a very comprehensive tool that a subject will undergo. It's hundreds upon hundreds of questions, but basically it's a tool that is utilized to establish if a person has committed said crime.
Or if they have propensities to, for example, sexually abuse children.
Yep, sexual deviant. I mean, there's lots of different scales on the psychosexual evaluation.
After you closed your investigation, did you learn that John Mast had taken the step of getting a psychosexual assessment done?
Yes, I did.
And did you learn the results of that assessment?
That he passed. No concerns.
Did that surprise you?
Not at all.
Did that, in fact, correlate with everything you found in your investigation?
Absolutely.
Did you ever start to develop concerns about the truthfulness of the information that Rebecca Brashier was providing?
I did.
And what were your concerns?
I have done this job long enough, and based upon my own case files that I've worked, there was just not a stitch of evidence that supported any type of sexual abuse allegation against John Mast. And I just, at one point, I don't know, and I can't speak for the motives. I don't know, but from my perspective, it was very apparent this was a god-awful custody battle. There was a very spiteful, revengeful type situation going on. And again, I cannot speak for motives, but from my perspective in this, when it was all said and done, it was very apparent that the children were getting traumatized and thrown into the middle of a horrible custody battle.
So ultimately, and I think you've already testified to this, you closed your case on
Yes,
John Mast.
I did.
And you have, as you sit here today, do you have any concerns that you made the right decision?
100% support my decision to close that case with no charges.
Did you meet with Rebecca Brashier's? I'm assuming when you start to close something like this and you've got a family member, a parent, you're going to want to meet with them in person to tell them what's going on. Is that fair?
Yes,
Is that what you did in this case?
I did meet with Rebecca and her parents at the law enforcement center.
So her parents, James and Robin, came with her as well?
Correct.
And how did that meeting go?
It did not go well.
What happened?
Very upset, very emotional.
Well, can I stop you for a second? Were you expecting them to be relieved to find out there was nothing going on?
I don't know what I expected, just because the whole situation was very odd to me. And like I have said repeatedly, they were very aggressive with the allegations and with the information. Truthfully, I don't know what I expected, but I remember the response was kind of threw me for a loop even more. You know, as a mom, and this is outside of my scope as law enforcement, but as a mom, I would be relieved if I found out that nothing had happened to my child. So it was like they were so frustrated and so mad that they wanted something to be there that wasn't.
And it sounds like they couldn't have picked anyone else in the world better to have investigated this than you.
I don't mean to sound arrogant, but that is what I'm very passionate about.
That's just where your heart is.
Very much so.
So were they angry?
Hostile.
What do you mean hostile?
I remember at one point, James got very upset and struck his cane against my table leg in the interview room, and was very upset that I was not pressing charges against John. There was some conversing in that room, and they were so upset there was a threat made. And verbatim, I don't remember exactly what it was, but I do remember having to settle them down and remind them, you cannot make threats to me. I'm a law enforcement official, and we don't get to talk like that.
Was the threat to you?
No.
Who was it to?
To John.
John Mast?
Yes.
And who made that threat?
James.
Did they then leave your office?
Yes.
May I approach the witness?
You may.
Okay.
This is a two-page document, Sergeant. Can you identify what this is?
Yes, this is a letter that I had wrote to Robert and Sarah Mast after they had sent me a letter. That's page 1. And then page 2 is the no charges memo that I had received from the Williams County State's Attorney's Office in this matter.
You wrote this letter?
Yes, I did.
These are all your words, and it says respectfully Danielle Hendricks at the bottom.
Yes.
And it's dated June 1st, 2021?
Correct.
Your Honor, we request this letter, this two-page document be admitted. It's Plaintiff's Exhibit 1.
Mr. Brashier, Ms. Brashier, Mast, any objection?
No, Your Honor.
Exhibit 1 will be admitted.
Where have they marked it? Why did you write this letter?
So I had received a letter from John's mom, and she was heartbroken. She had just lost her son. And I think more than anything, she was trying to find peace. She was trying to find closure. She was trying to find answers. And I think she just wanted to know why. Why would this happen if he was cleared from these criminal investigations? Why did he have to die? She also had some questions because CPS had listed, and CPS for me is our local social services, had coded something. So I obviously wanted to provide maybe some peace and comfort to a grieving mom, and kind of explain a little bit from the social services side of things. That is why I chose to write her back.
Do you mind reading this letter?
Absolutely. Dear Robert and Sarah Mast, first off, I want to start this letter by sending my deepest condolences for the loss of your son. There's no greater pain than losing a child. Secondly, I want to introduce myself. My name is Danielle Hendricks, and I'm an investigator or detective for the Wilson Police Department. I was the primary detective on all of the cases and circumstances you mentioned in your letter. I want you to know that anytime there is a report of suspected child abuse or neglect, it is the utmost priority to ensure the safety of the children. I know firsthand, as I have worked the cases with John, there was no sufficient evidence to establish that your son had done anything wrong or committed any crimes. John was beyond cooperative with all the criminal investigations and even went as far as consenting to do a polygraph, which he passed. My criminal cases with John were closed years ago, no charges filed. As far as CPS, I'm unable to give answers or reasons for things their departments do. You are in my thoughts and prayers. If you need anything else, please feel free to reach out. Respectfully, Danielle Hendricks.
Thank you. So they mentioned CPS to you. So apparently Rebecca was still making allegations?
There
Or
was
do you
still,
know?
I think to my understanding, there was still an open CPS assessment being conducted.
Sergeant, you've said you are a huge child advocate.
Yes, sir.
Do you feel that these children are safe?
No.
Why not?
I feel like they've been exposed to the most unbelievable situation, toxic environment. These poor children lost their dad, who was just fighting to see them. I think there's some serious mental health concerns, and I think these children just need to be in a safe environment.
Do you think they need to be out of the environment they're in now?
I do.
That's all I have.
Objection, personal knowledge.
Judge, it's already been answered, and it's just her opinion.
Overrule the objection on personal knowledge, I think. But that said, any cross-examination?
Yes, Your Honor.
But Mr. Brashier, I'll let you go first.
I have none.
Mr. Brashier Mast, you may proceed.
So you mentioned a forensic performed in Minot, North Dakota. Did the children express fear in that report?
Do you have the reports? I'd like to refresh it.
I did not have that report. Did John Mast admit to giving Zane alcohol?
I believe there was some notations of alcohol being given at some point, yes.
Did the Minot forensic show domestic violence?
Do you have the report?
I do not have the report.
I don't want to speak verbatim to what was in the report without having an actual
Yes, I just
copy.
thought you'd have knowledge of that since you're the expert, but yeah. Oh, that's right, you're not an expert, you just have a lot of knowledge, okay. Are you aware of a forensic John Mast requested by Davidson Forensics out of North Dakota?
A forensic interview of the children?
Correct.
I'm not aware. If you have that documentation, I'd review
No,
it, but
I
I'm not
don't.
aware.
Are you aware of a forensic performed in Coeur d'Alene, Idaho at the Children's Advocacy?
I know there was one completed in Idaho, yes. Which is the one I reviewed when I spoke earlier.
No, that's a secondary one. There's one from Detective Eiler and there's one in Coeur d'Alene, Idaho as well, at a Children's Advocacy Center.
So for my investigation, there was 2 forensic interviews done.
So there's a total of 4.
Objection.
Well, okay, Ms. Brashier, Mast, I'm going to ask you to ask questions and not make commentary.
Yes, Your Honor. Did you make the statement that the children are quote unquote safe in Idaho and that you rescued 30-something children this week and that was a priority to investigate or something to that effect? At one point.
Judge, I'm going to object. We'd like some foundation for that. I'm not even sure what that is.
Let's do this. I'm going to excuse the jury just for a moment while we can work through this. Ladies and gentlemen, members of the jury, may I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. I'm going to excuse you back to the jury room just for a moment while we work this out. We'll be right back with you. Please rise for the jury. Okay, go ahead and be seated. Looks like our door's closed. All right. Mr. Hicks, you have some, or Mr. Hickey, I'm sorry, you have some concerns about where we're going?
Well, I only heard part of it. It sounded like it's something that's completely unrelated to this case, and I was asking for some foundation to that. I don't know what the
Okay.
relevance is.
Let's suss that out right now before we bring the jury back.
Sure. So I'm leading up to how the investigation was performed.
And you had a question to her with
That
regards
is
to
correct. A quotation.
a statement that she
Yes,
made?
a statement that she made.
Is it contained in a document or in a report or
That is
something?
not, I do not have that, but
Okay.
I do have a witness who will verify that statement at a later time.
Okay.
Can I hear the question again?
Yeah, let's
Could
ask
we do
them to
that,
hear the
Judge?
question again.
Absolutely. Did you make the statement that the children are safe with you in Idaho, that I rescued 30-something children this week, and that was a priority to investigate or something to that effect?
She's asking about it. She did.
Do I need to answer this?
Let's,
I think it's either she remembers it or she doesn't, I guess. I don't know.
so the question is phrased like that, and I guess as an offer of proof,
I don't recall this statement.
okay.
I mean, anything's possible. Obviously, I work a lot of child crimes, but I don't recall the statement at all.
Okay.
Anything else that,
Have other questions?
okay, I just want to make sure that
But I
with regard to
understand not
this,
recalling it.
and I guess that's going to be the question, if there are statements, the question would be, did you make the statement or do you recall making the statement? And to the extent that's what it's asked for, I'm going to allow you to answer yes or you don't, and then depending on what that is, we may have to take it up separately, but, all right. Mr. Hickey, anything else?
Not on that issue, Judge. no.
Okay. All right.
And no,
And anything else that we need to take up before we return the jury?
I don't believe so.
Okay, so when we come back, Ms. Brashier, Mast, I'm going to allow you to ask that question,
Thank you,
and I'm
Your
going to allow
Honor.
you to answer that question, all right? So please rise for the jury.
Blind.
One in the restroom.
Oh, okay. You got water, you got.
Yeah, I'm good. Thank
Oh, you can tap the side of that and start screaming. Yes.
Sorry. Hopefully it was on.
I think it will pick you up, but it just hits you there, so.
Yeah.
Say, the 16 years at moving target right now, so.
And you get more of the memory problems.
Paper towel. Or Kleenex.
Clean up.
Oh, we got
You
one.
want, you want Kleenex?
We got it, Joe.
Oh, that's unfortunate.
Doing okay over there? You need more Kleenex?
Oh, we're good, thanks.
Thank you. You may be seated. And the record will reflect the jury is returned. They appear to be properly seated. Will the parties stipulate that the jury is seated and all accounted for?
Yes.
All right. That being said, Ms. Brashier, Mast, you may continue to inquire.
Yes, thank you. Did you make the statement that the children are safe with you in Idaho, that you rescued 30-something children this week, and that was a priority to investigate or something to that effect?
I don't recall making that statement.
How long did the investigation take?
Approximately February 2018 to, I believe, August of 2019.
Is that a long time for an investigation to take?
Every investigation is different.
Why did it take so long?
The amount of data that was coming in and the information constantly being, new additional information coming in, new reports coming in, and there was a lot of extra factors outside of the child sexual abuse that were being reported.
Would you be angry if you believed your child had been molested and the law enforcement officer failed to arrest the abuser?
Objection, Your Honor. That is argumentative.
I'm going to sustain that objection.
Okay. Do you have any personal knowledge of John's death?
Personal knowledge or through my employment?
Just personal knowledge.
I know John was murdered, yes.
Do you have any personal knowledge of threats made by me towards John Mast?
You were present in that room.
But did I personally make any threats towards John Mast?
I don't recall. I'd have to review my entire case file.
Were you at the apartment before John Mast's shooting?
Can you
Were
repeat?
you at my apartment before John Mast's shooting?
Was I at your apartment
Yes.
before he was murdered?
Yes.
I had never been to your apartment.
Were you at Rosar's during or after the shooting?
No.
Do you have any personal knowledge of the children living in an unsafe environment?
I believe that I do, yes.
Have you ever been, when did you last see the children?
I'm just giving my opinion is what you asked.
No, when did you last see the children?
When they were in North Dakota for the forensic interviews.
How long ago was that?
2019.
How does that give you personal knowledge of the children?
I believe that the environment that the children are in is unsafe for them.
How can you believe that if you haven't seen the children's environment since 2018?
The physical environment is only one aspect. There's emotional well-being of the children. There's mental instabilities that I have concerns for. Obviously, they were exposed to a situation where their father was murdered. Those are my concerns. They've been isolated from their father's side of the family. That is a huge concern for me.
And how do you know why they've been isolated?
Because there's been no contact, has there not?
There has been no contact.
Okay.
There's also no grandparents' rights, and I'm a parent and I have that right to make in the state of Idaho.
Okay. My training and experience in child well-being and child development, it is crucial to have those elements of the family dynamic for children and their best interest. My opinion, so take it with a grain of salt, these children have been in an emotionally unstable environment since this whole ordeal started. These children have been exposed to gun violence. They've been exposed to their grandfather murdering their father. They've been exposed to multiple forensic interviews, which is unhealthy for children. We're traumatizing children. We're re-victimizing children. These children have been the center of a horrible custody dispute.
Are you aware that that has been
Judge,
completely?
Your Honor, the witness is in the middle of her answer.
I don't know if you were done, but
Not yet, but you can go ahead.
I'll go ahead and allow you to
Are
ask
you
your
aware
question.
that that was all done at the recommendation of law enforcement and social services?
I was your law enforcement representative, and that was not done at my discretion. I never once told you to do any of that. I never once suggested that you murder him or your father murder him either.
Has there been any proof that I have murdered John
I
Mast?
corrected myself. I said your father.
I will rest my case.
Okay. Thank you.
All right. Mr. Hickey, any redirect?
Just briefly, Judge. You were asked by Ms. Brashier about why it took so long, this investigation, and I think you had testified it because you kept getting new allegations.
Yes, correct.
Was a lot of that Ms. Brashier regurgitating the same allegations?
Yes, and to emphasize, there was, the core of my investigation was to establish if these children were sexually abused or not, right? That was the core basis of my investigation. However, there was repetitive new information coming in. Oh, he's harassing us. Oh, he's sending us packages. Oh, he's showed up in Idaho. Oh, he did this. Oh, he did that. And so I would have to stop and divert and triage all of the new information constantly coming in. Every single time there was more information coming in. There was also the civil side of things going on at the same time. There was open CPS assessments going on at the same time. So when I say it took that long, it was because there were so many extra moving pieces outside of the core focus of the sexual abuse allegations.
So when she would make these either new allegations or new information, you can't just set that aside. You have to then say, okay, I got to look at this now. Is that fair?
Well, and in my defense here, I was banging my head up against the wall thinking, what am I missing? So maybe all of this new information that's coming in will help me dig into the core allegation, and it just never did.
And so it took that long because you had to be thorough with everything you did.
100%, yes.
And finally, you're not being paid for your testimony. Is that correct?
I'm not here on a subpoena, no.
Okay. But you're not being paid.
No.
That's all I have.
Thank you. Mr. Brashier, any questions?
No, Your Honor.
Ms. Brashier, Mast, any recross on this? Go ahead.
Is it fair to say that I won't be able to produce any documents that show that he actually molested the children?
Objection, Your Honor. To the form of the question, I'm not even sure what the question is.
Can you rephrase I'm going to sustain that objection. I'm going to ask you to rephrase the
Okay.
question.
Is it fair to say that there is no documentation that the children were abused?
I'm going to object to the form of the question.
Is it fair to say that there was no CPS documents that show that the children have been abused?
Well, no, now we're
Okay,
now
so
we're dealing with hearsay.
we've got, so the objection is to the form of the question, and the question is it fair to say there are no documents that show abuse? Is that correct?
That is correct.
And you've got an objection to the form of the question?
I do, and also the second part of the question, she mentioned CPS. Now we're getting into hearsay
Okay.
documents.
Is it fair to say that?
Hold on a second.
Is it fair to say that there's no documents?
Well, I need you to stop for a second. What I'm going to do is I'm going to sustain that objection. I'm going to ask you to rephrase your question.
Okay. Is it fair to say that there are no documentation related to, no concrete documents related to sexually abusing or the abuse of Zane and Ashara Mast?
I don't understand the question. I apologize. I'm not trying to be difficult.
No, that's okay.
Are you asking if there's any paper documentation?
Solid documentation that's standing.
There was zero evidence that John had sexually abused the children. However, I want to clarify, You keep saying documents. So yes, there was 960 reports filed by you through CPS. So technically, there is CPS allegation
And
reports
there's no other documentation.
through CPS.
Yes.
I can't speak for what CPS has on
So you
record.
can only speak to law enforcement.
I can't speak to their case files, their reporting, their recording systems. I don't know what kind of documentation CPS has.
Understood.
Okay.
No further questions.
Thank you. Sergeant, you step down.
Okay, thank you.
Thank you for your time.
Yeah, of course.
Yes. Your Honor, may she be released?
She may.
Thank you.
All right, Mr. Miller, Mr. Hickey, you may call your next witness.
Judge, can we take about a 10-minute break?
We may. Why don't we reconvene at 2 o'clock? Ladies and gentlemen of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. Please rise for the jury. Let's take 10 minutes. Okay, seeing 10 minutes.
So Dave, when we take our breaks, are you guys still live?
back in session in Mast v. Brashier, Nez Perce County case CV 35-23-195. Plaintiffs are present at council table with their attorneys. Mr. Brashier, Ms. Brashier Mast are also present, the defendants. We are outside the presence of the jury. Counsel, Mr. Brashier, Ms. Brashier Mast, anything that we need to take up before we bring the jury back in?
We have a couple of housekeeping.
Mr. Hickey, go ahead.
Some exhibits. First of all, this memorandum of opinion, we just want to make sure we have this marked correctly as Defendant's Exhibit J. It's been stipulated too, but we just want to make sure we've got that.
That's the entire one, is that correct?
Correct. May I approach to look at
You may,
that?
please do.
Thank you. And then we have two exhibits, Judge, that are self-authenticating that we would like to introduce. One is Plaintiff's Exhibit 5 is the criminal judgment as to James Brashier.
Okay.
And then Plaintiff's Exhibit 6 is an interim order from the John Mast versus Rebecca Brashier Mast divorce, and we do have Plaintiff's Exhibit 6 is a certified copy.
I was curious about that. I did see that Plaintiff's Exhibit 5 is a certified copy. And sounds to me like you're asking, and 6 is a certified copy as well?
That is correct, Your
All
Honor.
right, Mr. Brashier, Ms. Brashier Mast, any objection to the introduction of those exhibits?
No objection.
Okay. Yeah. it's
No
not-
objection.
All right.
No.
So, no objection. We raise the exhibits. Those are exhibits 5 and 6.
Yes, Your Honor.
So 5 and 6 will be admitted.
I think that's all we have, Judge.
All right. Ms. Brashier Mast or Mr. Brashier, anything else that we need to take up from your perspective before we turn to jury?
No, Your Honor.
Oh, God.
Just a moment to make a notation here. Leave this subject. I'm gonna bring this up right now. Given that Exhibit 6 is the judgment of conviction in the criminal case. No, I'm sorry, Exhibit 5 is a judgment of conviction in the criminal case. I'm assuming that may impact, I'm looking to you in terms of claim preclusion, in terms of a wrongful death count as to Mr. Brashier.
Oh, as
Mr. Hickey or Mr. Miller,
I'm assuming you mean as to a
as to whether
race
that-
judicata type of issue?
Correct, as to collateral estoppel.
That's one thing we've discussed,
Okay.
but have not finished
All right,
discussing.
I'll allow you to finish discussion. I want you to be aware that that's on the court's radar.
It is on ours as well.
In terms of, I think that could affect potential jury instructions in this matter, so just tuck that away. We'll have further discussions about that as the time comes forward, so, all right. That was just a commentary from the court in terms of a housekeeping matter that I suspect is going to come up. All right, anything else that we need to bring up before we return to the jury?
Don't believe so,
No, Your
Judge.
Honor, thank you.
Okay, let's go ahead and rise for the jury.
I think that's right. Yeah, I do.
Okay, you may be seated. Thank you very much. And Mr. Miller or Mr. Hickey, you may call your next witness.
Thank you, Your Honor. Call Rebecca Brashier.
Okay. Ms. Brashier, if you will come forward, I'll have you face my clerk and be sworn.
Do you affirm under the penalty of perjury that the testimony you'll give in this matter shall be the truth, the whole truth, and nothing but the truth?
All right, Ms. Brashier, I'm going to have you sit down. that is on, make yourself as comfortable.
Yes, thank you.
What I'm going to have you do, like I did with the other witnesses, is just spell your name so that we can make sure that we can hear you okay.
It's Rebecca, Rebecca, Brashier, Brashear -Mast.
And ladies and gentlemen, are you able to hear Ms. Brashier Mast? All right. Mr. Hickey, you may inquire.
Thank you, Your Honor. First, we would request to treat the witness as hostile since she is a party opponent.
I will grant that request.
Thank you. Do you still live here in Lewiston, Ms. Brashier?
I do.
Your husband, John Mast, filed for divorce in January of 2018 in Williston, North Dakota, correct?
Yes, he did.
May I approach, Your Honor?
You may.
I'm going to show you what's been marked as Plaintiff's Exhibit 6, and you can keep that to refer to. This is an interim order that came out of a interim hearing that was held in your divorce in May of 2018. Is that correct?
Yes.
And you were present and you testified at that temporary hearing, that interim hearing?
Yes.
I want to go through this order. Let's look on the first page. Okay, 1 second, Judge.
You
I'm
may.
going to pull that up. Okay, we'll go down to paragraph 4. And this is the judge's findings after that hearing, correct?
Correct.
Will you read paragraph 4, please?
There is not sufficient evidence before the court to conclude that John has abused his children in any way.
So that was a finding by Judge Rustad in North Dakota.
Yes.
And again, you were present and you testified at that hearing.
Correct.
You also testified that John Mast had assaulted you outside of a local restaurant. Is that correct?
Correct.
And the name of that restaurant was Basil?
Yes.
Basil Restaurant? And you also claimed that he had severely injured your shoulder, correct?
Correct.
Now, there was a video of what took place in the parking lot between you and Mr. Mast, isn't that correct?
Correct.
And the judge at this interim hearing reviewed that video, is that correct?
Correct.
Would you please read paragraph 5 of the interim order?
The evidence presented to court does not support Rebecca's claims that John physically abused her. Rebecca claimed that John physically assaulted her at the Basil Restaurant in Williston, North Dakota, and the assault resulted in a significant injury to Rebecca's arm. John showed a security video of what occurred at Basil, and it is clear that John did not assault Rebecca. Since Rebecca was not honest about what occurred at Basil, the court finds that Rebecca's testimony is not sufficient to find that John perpetuated the other acts of violence and threats of violence alleged by Rebecca.
So basically, he said you weren't truthful in what you said, correct?
Correct.
And also found that no abuse had taken place, despite what you had told the court, correct?
According to this interim order.
And the judge did
The
this.
judge did this order.
Let's go down to paragraph 7 of the interim order. And would you please read that paragraph, the number 1?
Therefore, it is hereby ordered that for the interim, John Mast is awarded primary residential responsibility of the children, and that the children must be returned to John Mast immediately.
Now, this hearing was back in May of 2018, but this order wasn't entered until August of 2018, correct?
Correct.
So several months went by. But John was awarded custody of these children.
Correct.
And he got custody of them, is that correct?
Correct.
And he had them for about what, a total of 5 days before you started blowing up the phone to CPS to get an investigation started in North Dakota, correct?
Correct.
And that's the investigation that we just heard Danielle Hendricks talk extensively about, correct?
Yes, at the advisement of law enforcement, I called CPS.
So the kids are taken away from John as a result of your actions, and they are put into foster care for 2 months, correct?
Yes, at the advisement of law enforcement, I called CPS and followed through what
Ma'am, I don't
provided
care
the
who
social
told you. You
services.
picked up the phone and chose to call and do it.
Absolutely, I did exactly what I was supposed to do.
So let's go to December of 2020. This is Defendant's Exhibit J. It's technically your exhibit. Here's a copy we can use. So Judge Rustad was the judge throughout your divorce, correct?
Correct.
And he made the ultimate determination in your case.
Yes.
And that is contained in this December 16, 2020 Memorandum of Opinion. Is that correct?
Correct.
Let's go to page 15 of this memorandum. Second to get there. Okay. John was the plaintiff. He filed for divorce from you, and you were the defendant, correct?
Yes.
Do you see the paragraph that says, as was addressed earlier?
Yes.
Would you read that paragraph,
As
please?
was addressed earlier, the court has very real concerns with defendant's lack of willingness to foster a close relationship between plaintiff and the children. The court does note that defendant's attitude towards plaintiff has negatively impacted plaintiff's relationship with the children. This factor favors plaintiff.
So Judge Rustad found that you were causing problems between the children and John and their relationship, correct?
According to the judge, yes.
Yeah, the one that decided your case.
Correct.
You clearly disagree with him, right?
Yes.
You disagreed with a lot of orders in this case, right?
Yes.
Are there any, well, I'll ask you that in a minute. Let's go to page 18 of Judge Rustad's order. We'll go to the bottom. Slowly.
Yes, sorry. I'm kidding.
I know. It's okay.
Trying not to get that
Yeah.
far.
Okay.
Okay.
Do you see the paragraph that says the court does not?
Yes.
Would you please read that
The
paragraph?
court does not find sufficient evidence to establish domestic violence has occurred, triggering a rebuttal presumption. The court does find no pattern of domestic violence or any incidents involving serious bodily injury or use of a dangerous weapon. As such, this factor favors neither party.
So that was as a result of the allegations you've been making for 3 or 4 years. The judge found what he just said in that paragraph, correct?
Correct.
Nothing.
Correct.
Let's go over to page 20 of the memorandum. If you go down to the bottom third, you see where it says the court is certainly concerned?
Yes.
Please read that paragraph.
The court is certainly concerned with the allegations regarding abuse perpetrated on the children by plaintiff. However, the court does not find sufficient evidence that such abuse has occurred. There are simply too many red flags regarding the statements to make any definitive judgment. As such, this court will make no finding that any alleged abuse has occurred.
And many of those red flags were due to your involvement and your coaching of these children. Isn't that correct?
That is not correct.
Let's go to the next page, please.
What page would that be?
Page 21. That's good. Do you see where it says beginning?
Yes.
Would you read that
Beginning
sentence?
the first weekend of February 21, plaintiff shall have parenting time every other weekend from Friday at 6 p.m. to Sunday at 6 p.m.
All right, that's good enough. Thank you. So that's when the visitation was supposed to take place. was the first weekend of February, which was February 5. Is that correct?
That is correct.
And this was ordered back in December 16 of 2020.
Yes,
Correct?
that is correct.
And you knew that.
I did know that, yes.
All right, let's move forward to February 5, 2021, when the custodial time for John, ordered by Judge Rustad, was supposed to take place. You remember that day, correct?
Yes, I do.
That is the day that your father shot and killed John Mast,
Yes,
correct?
that is correct.
You were with your father that entire day,
Yes,
all the way until about 20 minutes before he went to Rosar's, correct?
it was give or take probably a little bit longer than that.
Okay. Well, I mean, about 5:40 p.m., is that when he left you?
Probably about that.
Most of the day or all of the day, the two of you were in the same vehicle together, correct?
Yes, we were together.
So John was supposed to get the children at 6 p.m. that day, correct?
Correct.
And that was per the order that we just looked at, correct?
Yes, that is correct.
And despite that order, you and your father were going all over Lewiston trying to find a way to prevent that from happening, correct?
Absolutely, I was. Yes, 100%.
And by 5 p.m., you knew your attempts had failed.
Yes, I did.
You were at the courthouse at that time, correct?
Yes, I was.
So you and your father get in the vehicle together and drive back to your apartment.
Yes, I did.
Who was driving?
I can't remember who was driving. That I can't recall.
What vehicle were you driving?
I actually believe it was the white vehicle, but I can't recall.
And I think we heard that it was like a white Kia.
I don't remember. It was a white vehicle. It was a white hatchback SUV of some kind.
And that was the vehicle that earlier that day your dad had driven from his home in Winchester to Lewiston.
Yes, as far as I know.
And you guys, that was the vehicle you were in most of the day.
I believe so, but I would assume we were driving that because the brakes were bad on the Suburban. I would
Okay.
assume that was what we were driving.
So as you're leaving at 5 p.m., leaving the courthouse, I'm assuming you're pretty upset.
Oh, I was very upset.
Your father was upset.
My father was upset, but I was upset because I knew the kids had to go to their visit at that point.
Because you knew you'd be arrested if you didn't. Or could
That
be.
is, well, I knew I would be if I didn't go to the visit. My attorney had advised me that I needed to take the children to the visit.
Because you'd be in contempt of the court's orders.
That is exactly right.
In fact, didn't she advise you that there would be a chance you might even lose custody of the kids if you didn't take them?
She 100% told me that. She said, this time you need to be there, be on time, make sure that no matter what, you get the kids there. This is the end of it. There's no messing around. If you want to see your kids again, make sure you get them there. So I didn't want to be late or, I needed to be there.
So basically everyone, including your own attorney, is telling you you need to comply with this order.
100%.
And you and your father still didn't want to do that.
Well, she told me go ahead and go around and see what you can do. Follow the safety plan the CPS had in place, which was to alert them if John was to try to gain custody of the kids. That was the safety plan. But if that failed, I needed to take the kids to the visit. That's what had to happen. And
Do you recall?
CPS said that if they didn't,
Objection, hearsay.
then step
I'm going
in.
to sustain that. I'm just going to have you respond to his question.
Okay.
Do you recall testifying at your father's criminal trial?
I do recall.
you testified that the morning of February 5, 2021, you had no idea that the visitation was happening that day.
I had absolutely no idea that the visitation was happening that day.
This memorandum was from December and told you when the visitation was happening.
I didn't think that it would be an unsupervised visit. I thought that there would be a visit, but I did not think that it would be an unsupervised visit.
Ma'am, there's nothing in this memorandum that says anything about it being a supervised visit. Nothing.
I know, but my attorney assured me that it would be a step-up plan of some kind because he hadn't had court-ordered visits in a very long time. And there was a lot of communication back and forth between attorneys. So needless to say, I was
That's not a
blindsided.
question. We're going to pull up a text message. You said you didn't know until that morning that that visitation was going to take
Well,
place.
it was more
But you,
like
ma'am,
10 or 11.
I'm not finished with my question. So, but you did know the night before because you were talking with your father about it, correct? That's yes or no?
That's a yes. We knew that there would be some kind of a visit. We just didn't know whether it would be supervised or unsupervised. And honestly, we thought it would be supervised.
And you knew it would be at 6 p.m.
I didn't know if he'd actually show up or not.
Ma'am?
That's kind of,
Your father texted you and said, "Did you tell me the visitation's at 6 p.m. tomorrow?" And you responded and said yes.
Yes.
That was Thursday night.
yeah, but we didn't know if he'd show up.
That's your answer?
Yes, that is my answer, because they did get canceled quite a bit.
Just 1 second. May I approach, Judge?
You may.
To show you what was marked as Plaintiff's Exhibit 3, and is this the text message that your father sent to you?
Yes, it is.
Okay, thank you.
There's nothing different than what I'm saying.
Your Honor's request to be admitted as Plaintiff's Exhibit 3.
Any objection to plaintiff's exhibit 3?
No, not at all.
Mr. Brashier,
No.
exhibit 3 will be admitted.
So this was it. Looks like we got military time. The night before John was killed, 4:49 p.m. Is that no? This is 20. So this is yeah. So 8 p.m. 8:49 p.m. at night. He texts you and says, "Did you say the original document said John would pick them up at 6 p.m.?" And you responded and said yes.
Yes.
Okay. You heard Detective Crane testify that he downloaded the data off your phone and off of your father's phone.
That is correct.
And that also included phone calls.
Yes.
Now, the text says, "Did you say?" which kind of indicates that you and your father had even talked before that text message. Correct?
Can you repeat that?
Yeah, the text says, "Did you say it was going to be at 6 o'clock?" as if y'all had talked about it earlier. Did you talk about it earlier that
I
evening?
can't recall. It's been years.
Okay. Well, within an hour before this text message, you and your father had a 46-minute phone conversation. Do you remember that?
No, I don't remember at all.
And
It's been years.
okay. Well, you did. You don't deny that, correct?
No, I don't deny what I can't recall.
But you're saying the visitation with John was not the subject of that phone call, or you just don't
I
remember?
can't recall.
So it could have been.
I don't.
And you're actually referencing, when you say the original document, you and your dad are referencing this Judge Rustad order from December, correct?
Correct, but I don't know that it wouldn't be supervised.
So your dad knew he was supposed to get it as well, the visitation.
Supervised visitation, yeah.
Ma'am, there's nothing in that order that says anything about supervised. Do you disagree with me about that?
Hasn't stated, my attorney has assured me that it would be supervised. She was working on that. And up until that point, I trusted my attorney to do a good job. I didn't expect it to go any different.
So, staying with February 5, 2021, earlier that day, your dad drives down from Winchester in the white vehicle, and he meets you for a meal
Yes,
around breakfast or lunch.
10, 11 o'clock,
And you're saying that's when you get the phone call from the lawyer.
absolutely. I got the phone call from my attorney.
And that attorney's in North Dakota, correct?
Correct.
And that she was calling you because you had filed something or were trying to file something in North Dakota to again stop this visitation from happening.
She was working on communication. She was talking to his attorney, as was my understanding, and then she was filing things. She had been working on stuff, basically saying he hadn't had visits, didn't have a known address, various reasons why she could have a step-up plan instead of having that happen.
So that's a yes. You were trying
That's
to
a
get her to file something.
Yes.
And she told you that's not going to work.
And then she told me it's happening. Today's the day. This is what you got to do. He's getting the kids. Be there, be square. And I was in shock.
And that's when you and your father started trying to take other actions here in Idaho to stop the visitation.
First, she told me go follow the safety plan CPS had in place. And if that all else fails, take the children to the visit and don't be late. She said, get them there within the 15-minute window.
So you tried to get a restraining order against John here in Lewiston, correct?
I did. I followed the recommendations of CPS.
You and your father went to try to get a restraining order against John,
I
correct?
followed the recommendations of CPS.
But you made the decision to go try to get that restraining order, correct?
Oh, absolutely. I 100% did. I
And
was
in
protecting
fact,
my children.
for years, you've been trying to get restraining orders against John, correct?
I obtained a restraining order at one point, and I tried to get restraining orders against John for the protection of the children. That is correct.
In Idaho, before that day, that was the fourth attempt, but before that day, you tried at least 3 other times to get restraining orders in Idaho, and all of them were dismissed, correct?
That is correct.
And this 4th attempt failed as well.
Not necessarily. They said
Did you get one?
wait until Monday to make a decision on it.
Did you get a restraining order Friday?
I didn't get a restraining order Friday. They said they'd make a decision on Monday, but the children were already going to be in his custody by then, so it didn't really make a difference.
By the end of the day, or really throughout that afternoon, I think you've said before that you and your father were frantic trying to get this done.
We were I especially was frantic, but definitely just trying to, I wouldn't say frantic as much as, well, I would say frantic. I would say it was definitely busy and trying to get things done.
You said frantic in your deposition.
Yeah, I would say frantic.
When you were under oath.
Yeah, I would say frantic.
You were feeling a lot of panic.
Yes.
And as all these efforts failed throughout the afternoon, you finally got desperate, isn't that correct?
Desperate, but still I followed anything that was legal.
Well, you didn't follow the North Dakota order for John to get the kids at 6 o'clock, did you?
Yes, I did. I was there at 6:02.
Did he get them that day at 6 o'clock, Rebecca? No, he didn't.
But that wasn't my fault. I was there at 6:02 with the children. I had absolutely nothing to do with John Mast killing. Absolutely nothing. I was there at 6:02 and I was just as traumatized as anybody else.
You and your father left the courthouse that day a little after 5 o'clock.
Yes,
You went back directly to your apartment, correct?
correct.
You're still in the white car.
Yes. As far as I know, we were in the white car.
You started packing things for the kids to take with them for the visitation,
Yes.
correct?
Mm-hmm.
After a few minutes, your dad decided he was going to leave, correct?
Hold on, I need just a second.
Take your time.
Okay, go ahead.
Let me see if I can help you. In your deposition, you said you asked, or your dad asked or decided to leave after he'd been at your apartment for a few minutes.
It wasn't a few minutes. He was there from because we got there just after 5, probably 5:10 or so. And I started packing up. He was downstairs with the kids for a little bit. I was upstairs packing.
And then you asked him what he was going to do, correct?
Correct.
And he told you he might go follow John, correct?
Yes, correct. I said that was a very bad idea.
And that caused you no concern whatsoever.
Oh, it caused me concern. That's why I told him not to do it. I told him that that would be shocking and he didn't need to do that.
Well, this is the first we've heard of this. You've testified at a criminal trial in your deposition, and this is the first time you've ever said, oh, you told him not to do
I
it.
told you that in the deposition.
Well, we'll get to that. He's told you multiple times in the past and to multiple people that he wanted to kill John, correct?
In a way, like how a father would, where he's like, oh, I could just kill the guy, but not in like oh, I'm gonna go kill him. That's not what I heard. I never heard him say, I'm gonna go kill John Mast. This is the plan. This is how I'm gonna do it. I never heard him do anything like that. It was more like, I could just kill him. I'm so upset. How could he do that to those children? Those are the kind of things I heard. The normal frustration.
When you left the courthouse and you were driving back to your apartment, at some point there was this phone call that's been called the Plan B phone call, correct?
Correct.
And that was a phone call between your dad and your mom.
Correct.
And that took place, though, on your telephone, correct?
I don't know if it was on my telephone or somebody else's.
You heard Detective Crane testify they had downloaded all the data off of your phone?
Correct.
Well, at 5:30 p.m. that day, there's a 6-minute phone call from your phone to your mom.
Okay.
So you think that was probably your dad?
Possibly.
Well, would you have been talking to your mom at that point?
I have no idea. I can't recall.
You overheard that call, correct?
I don't. I overheard the call, yes.
And you heard your dad and your mom agree that your dad should follow John.
I don't know if I would agree with that. I don't know if my mom was okay with it or not. Because I wasn't on the other end of the phone call. I just heard his side of the call, not her side. And knowing my mom, she probably would have told him it wasn't such a great idea.
We took your deposition back in September of last year, correct?
Correct.
And a deposition is basically when you are questioned by an attorney.
Yes.
Let me finish my question. And it's under oath, correct?
Correct.
So you knew you were under oath that day?
Yes, absolutely.
Well, we asked you about it, and you said, so you're talking about the Plan B phone call.
Uh-huh.
I mean, those were your words.
Yes.
So that's what you were calling it.
Right.
And you overheard what they said, right?
I overheard at least what my dad said.
May I approach?
May.
I'm going to show you lines 20, 25 from your deposition. This is on page 80.
I know that my dad made a phone call to my mom about, they had said that, he should follow John. So, I mean, it's kind of what I'm saying that he said to my mom. It's nothing really different.
So you did overhear their conversation?
I did overhear the conversation, but I don't know what my mom responded to him.
And also during that call, and this is 25 minutes before John was killed, your dad says, I guess we're going to go with plan B.
Yeah, I don't know if he said we're gonna go with Plan B or not.
Okay.
I can't recall.
Matt Frost.
Me.
Yeah.
Page 81 of your deposition, you're talking about your dad. You said,
Yeah, okay. Yeah, I
you
bet you
said,
did.
your dad said, I guess we're going to go to plan B.
Right, but I didn't think that was a good idea.
Well, I'm
And
not
I tried to
asking
talk him
that.
out of it.
I'm asking if you heard him say it. And you did, correct?
Correct. As I said, I told my dad it wasn't a good idea. Repeatedly.
But you didn't care if he followed him or not, is really the truth, correct?
No, I really actually did care, but my duty was to my kids and I was busy with my children getting them ready for a visit.
May I have continuing permission to approach, Judge?
You may.
Thank you. I want to show you page 79 of your deposition. This is your answer, page 79, line 12. He didn't say anything about John other than he might go follow John. And I was like, and then read the rest.
I don't care what you do at this point.
You didn't care what he did when he told you he was going to go follow John. This is your sworn testimony.
I know, I'm not responsible for my dad is what I meant. I'm not responsible for his actions after he leaves the house. He's an adult and I told him not to follow him. I was very clear with him. I had that conversation with him.
Your Honor, there's not a question. You knew that your father had a concealed carry permit, correct?
Correct.
You knew that your dad always, that was your word, always carried a gun.
Correct.
You can't remember him not ever having his gun on him, is what you said.
Correct.
You knew your dad had made comments about wanting to kill John in the past, correct?
Not with an actual motive behind it.
Ma'am, you've testified 3 different times prior that you did. Are you going to deny that today?
I'm not going to deny anything that I see as relevance, but I was very clear in my testimony that I don't believe that he actually would have followed through with it.
And I object.
What's your objection, sir?
I think he's badgering the witness. When he continues with the same questions over and over again, she's answered them.
Mr. Hickey?
I think there are a lot of different questions, and this is basically cross-examination since she's a hostile witness.
I'm going to overrule the objection and allow you some leeway in crossing rel, based on the fact that she has been determined to be a hostile witness.
Thank you, Your Honor. The evening that John was killed, you were interviewed by Detective Crane at the Lewiston Police Department, correct?
Correct.
And I think he testified a little bit about that earlier, correct?
Correct.
In that interview, you told him that your dad had said over and over again he wanted to kill, quote, that son of a bitch. You remember telling Detective Crane that?
Yes, I did.
But you're saying today you never heard your dad say he wanted to kill John before?
In a fatherly kind of way, not in an actual way where he would have actually gone and done it. It's the whole, like, I could kill that son of a bitch, but not in a, I'm going to actually go kill that son of a bitch kind of way. No, people say those kind of things on Facebook all the time where they're like, I'm going to go kill that son of a bitch. They don't actually go out and do it. I never expected. In fact, him saying it so many times made it to where I disbelieved that he ever would actually go do it. If I would have gone and picked up the phone for every time my dad said that he wanted to
Your Honor, I think this
kill
is
somebody,
non-responsive.
Yeah, that is non-responsive. Let's just have you confine your answers to the questions asked by Mr. Hickey.
Your Honor, can I see the exhibit that was denied yesterday? I can't remember the number. It's a plaintiff's exhibit.
Number 7.
Ms. Brashier, do you recall stating to John Mast that your father could go to his home in North Dakota and shoot him in the head while he slept?
no, never.
May I approach?
You may.
This is a note from John's Google account. Does that refresh your memory?
No, not at all. No, that does not refresh my
So
memory
you
at all.
deny you ever said that?
I didn't deny I ever said anything like that or ever saw anything like that.
Your dad told you sometime during the day on February 5th that he wanted to kill John, isn't that correct?
You said what?
Your dad told you sometime during the day on February 5th that he wanted to kill John.
No,
You disagree with that?
I disagree with that.
You heard Detective Crane's testimony earlier today?
I did, but here's the thing.
And that's yes or no. Did you hear it?
No, I did not hear that. I deny that fully.
I'm asking you if you heard Detective Crane's.
I heard Detective Crane said that.
Okay.
Crane say that.
He interviewed your father that night, and your father said he told you that day.
Yeah, but who are you going to believe, a convict or me?
Good question. Do you remember what Detective Crane testified to a minute ago? About that?
About what?
About what he told you, what your dad told you that day.
Please repeat that.
Detective Crane said, when was the last time you said anything like that? You'll kill him or want to kill him or you want him dead to Becky. And Jim said, probably today. You heard Detective Crane
he said
say that?
probably, and I don't remember hearing him say anything like that. The only time I remember him saying anything along those lines was in passing briefly with, I could kill the guy. And it was always done in a more of a nonchalant kind of way of being angry with the guy and just how you would say it if you were an angry parent or grandparent.
When you were back at your apartment getting things packed for the kids, your dad promised you that John would never get the kids by himself, didn't he?
No, he absolutely did not. That is not true.
You heard Detective Crane's testimony earlier today that James told him he promised you that.
And James Brashier, I regret to tell you, is not always truthful. I love my father, I absolutely do, but my dad's not always truthful.
Well, that's kind of a strange thing to bring up in a police interview, isn't it? That he told you that?
I hate to tell you, but it's not too cool.
He also told Detective Crane that he told you that day, I promised my daughter that he would never have them again by himself, much less take them home. And you're denying that he told you that.
I am 100% denying that James Brashier said that to me in the apartment that day.
And you heard Detective Crane testify that James told him that he decided while he was at your apartment that he was going to go kill John.
Yes, absolutely.
And that was within 30 or 40 minutes of John actually being killed.
Can you repeat that question?
That was within 30 or 40 minutes of John actually being killed when your dad decided that.
I don't know when he decided that because I don't.
Well,
How would I know when he decided?
Well, I'm just telling you, he told Detective Crane he decided it while he was at your apartment. You're aware of that.
I'm aware that he told Detective Crane that, yes. How is that relevant?
Ms. Brashier, oh, there you,
Oh, I blocked it?
well, it's bumping on and off.
Oh, sorry.
And you heard the testimony that your dad is known as the Fix-It Man, correct?
Yes, I heard that's
And you
relevant.
heard him proudly proclaim that at his criminal trial, correct?
Yes, I did hear him say that.
So your dad decided to leave the apartment, correct?
Yes, he left the apartment.
You were outside when he left.
Yes, I was.
You said goodbye to him.
I did, but we kind of got into it just shortly before he left.
You knew he took the Suburban when he left.
Uh-huh, he was gonna go fix the brakes or possibly follow John, but I tried to talk him out of it.
Your dad
Last
left
I
your,
knew, he was gonna fix the brakes, though. That's what I thought he was going to do.
your dad left your apartment well before you did, correct?
Yeah, he left well before I left. I would say that's fair.
And
Yeah.
Rosars is only about 3 to 5 minutes from your house. Is that fair?
That's fair. I was getting the kids ready to go.
So it's pretty close.
Yeah, I lived over by the fairgrounds when this all went down.
As he was leaving, you got that? As he was leaving, he gave you a big hug, told you goodbye, and said, "You don't have to worry about anything."
No, no, he didn't. That's not how it went
You can
at
have
all.
1 second, Your Honor.
You may.
Judge, we have the video of Rebecca's interview with Detective Crane, and we're offering it as impeachment.
The whole video or
It'll be a clip
Just a
just a
clip.
clip?
of the testimony she just gave.
All right,
We just wanted to advise the court of that.
I appreciate that. Thank you.
We can have 1 second.
You may.
I was trying to stop. I don't know if you need the audio, but we can try. Okay, it's ready.
We're going to see if the audio will work on this, Judge.
Yeah.
I'm getting lots of feedback.
Mr. Miller, do you want to take just a quick break? I think we may be able to. We did this exact thing in a trial I conducted a week ago.
Yeah.
And I know there's a way to do that.
Oh,
We would appreciate
Why
that.
don't we take a quick recess? The other thing, I don't know if you're on the Wi-Fi or if you're on the internet. If you're on Wi-Fi, it may be better to, why don't we take just a quick recess to get this squared away? Mrs. Jerry, I'm going to excuse you back there while we just get the sound issue resolved. May I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. This is just part and parcel of the new courthouse. We're still working through some technological kinks, so we're going to let
That's it.
Okay. Right.
Then if we need to impeach, maybe you can ask the jury to.
This is essentially refreshing recollection off the record. I get that. So, all right.
Thank you.
So. All right, let's go ahead and let's just go back on the record. We are back in session in Mast v. Brashier, Nez Perce County case CV 35-23-195. Plaintiffs are present with their attorneys. Mr. Brashier is at counsel table. Ms. Brashier Mast is on the witness stand. She's undergoing questioning by Mr. Hickey. We paused in order to take care of some technical difficulties. I think we've got those squared away. Anything we need to take up quickly before we return the jury?
No.
No.
Okay, let's go ahead and rise for the jury. Okay, you may be seated. Thank you. Ladies and gentlemen, note for the record, the jury appears to be returned properly seated. Will the parties stipulate that the jury is back and seated appropriately?
Plaintiff stipulated.
That the jury's back?
They are
All right.
back, yes.
Thank you. All right. With that, ladies and gentlemen, we think we've got our technical issues under control. Appreciate your patience with this. Mr. Hickey, you were in the process of inquiring. You may continue to inquire.
Thank you, Your Honor. Ms. Brashier, my last question for you was that as your dad was leaving, he gave you a big hug, told you goodbye, and said you don't have to worry about anything. And my understanding of your answer is that's not true and did not happen.
I did state that, and that is what I said. However, one thing I'd like to say is that that day was
Ma'am,
very traumatic.
Judge, this is non-responsive.
I'll strike that. Ms. Brashier Mast, I'm going to give you an opportunity to
Okay.
respond after.
Okay,
after
thank you. I
questions.
appreciate that, Your Honor.
You may continue, Mr. Hickey.
You understood my question just now.
I did
correct?
understand your
And you're
question.
denying that that happened.
I am denying that that happened.
All right. We'd like to play a portion of the interview that you had with Detective Crane the night John
Can
Mast was
I go
killed.
back to that question?
No. And this is kind of low.
Did he say where? Did he say where he was going? Did he say anything? What did he say when he was leaving?
He gave me a big hug and told me goodbye and told me you don't have to worry about anything.
That's you, correct?
Correct.
And that's exactly what I just asked you. Do you remember now that you told Detective
I
Crane
do,
that?
I do,
Okay.
yes. But
And at that point, after all that had happened that day, after all that had been said, you still weren't worried your father was going to go kill John, correct?
can you repeat that?
Yes. After everything that had happened that day, you still weren't worried that your dad was going to go kill John
No.
Mast.
I never once thought he would ever go kill John Mast.
Even after he said that to you, you don't have to worry about anything.
I didn't think for 1 second he would ever go kill John Mast. Ever.
Well, the truth is, when he was leaving, you really didn't care what happened. Isn't that correct?
If I would have thought he was going to go kill John Mast, I would have made a phone call to law enforcement.
You didn't care. Isn't that correct?
I would have cared. I would have cared about that. I wouldn't have cared if he was going to go fix the brakes. I wouldn't have cared if he was going to go over to Rosar's, but I would have cared about him killing someone. Because I don't believe in that kind of thing. I don't believe in gun violence.
This is as your father is driving off. This is page 95 of your deposition, line 12. Read that highlighted portion.
I went back as he was driving off. I was like, I really don't care what happens. I still don't believe in gun violence.
At that
I don't even
point,
own guns.
I was like,
I don't
really
even carry
care.
guns.
You knew what was gonna happen and you
I don't
just
believe
didn't
in
care.
gun violence. I would have made a phone call. And I know people believe in the right to bear arms. I'm not saying that that's a choice a lot of people make. I don't believe in gun violence. I don't shoot people.
I want to go back to something you said earlier today. And this is the first I've heard this from you. You said when you were talking with your dad the night before, you didn't know if John would show up or not.
I didn't.
John emailed you at 4:15 and said he would be at Rosar's at 6 o'clock, correct?
Correct.
After your dad left, you emailed John and said, I will meet you there with the children at 6 p.m.
Absolutely. I was going to be there at 6 p.m.
You didn't know if he'd be there or not. You sent this so that you would make sure he'd be there.
I wanted to make sure he was going to be on time so that the children wouldn't be disappointed if their dad was going to be there. And so that I could prepare to be there and I didn't pull into an empty parking lot.
May I approach?
You may.
This is Plaintiff's Exhibit 2. This is the email exchange between you and John. Is that correct?
Correct?
I'll try to.
Okay, thank you.
We'd ask this be admitted as Plaintiff's Exhibit 2.
Any objection to Exhibit 2?
No.
Mr. Brashier, any objection to admission of Exhibit 2?
I didn't see it.
Would you please show Mr. Brashier Exhibit 2?
Yes.
No objection.
All right, Exhibit 2 will be admitted.
Yep. Troy, can we use that for just a moment? Thank you.
Are you able to zoom in?
Yes.
Ms. Brashier, we're going to zoom in on this and let me know if you're able to read it, okay?
Okay.
Are you able to read that?
Okay.
I'm going to ask you about it, but I just want to see if you're
Who
able
is
to
it
see.
from? Okay, sure.
So John's email.
I see.
Okay, cool. John's email was sent to you at 4:15, correct?
Yes,
And he's asking if you can please send enough clothes for the weekend and things like that, right?
that is correct.
When did you read that email? He sent it at 4:15, but that doesn't mean you read it then. When did you read it?
I'm not sure. I can't answer that at this point. It's been years.
Well, you responded to him at 5:45. Do you think that's when you read it?
I'm not sure.
Why
I was
did you?
busy running around town doing things, so I'm not sure when I saw the email.
So you may not have read it
I
until
may
later.
not have read it until later.
Okay. So there's a chance you did read it and send it all at 5:45.
There's a chance I may very well have sent it later.
After your father left and you knew he was going to Rosar's and you wanted to make sure John would be there.
No, there's no correlation between that. I had nothing to do with my dad going to Rosar's. I know you're trying to paint a picture, but the fact of the matter is I intended to have the children there for their dad. I didn't like the visit happening. I was concerned about the children being harmed at the visit, but I always follow the law. And I talked to my attorney and she said that I needed to have the children there, so I was going to have the children there.
Did your dad accompany you to visitations at the supervised visitation?
Sometimes not.
And did you take him with you because you were concerned about safety?
At times, but once I started living alone, a lot of times I went on my own without my dad.
Okay. But you just said you were concerned about the safety at this exchange.
Actually, no, I didn't say that. I started feeling a lot more confident at one point, and honestly, I had been told I needed to communicate with John directly, and there was part of me that with my dad that I just felt like I'd rather just take the kids there.
So you weren't worried about John Mast being a threat at all?
I asked for a safe exchange from law enforcement, and law enforcement said that they would be close to the exchange site. They park at First Cinema Center. And I felt like having law enforcement there would be better than having a family member that might be an issue. So I asked for law enforcement to be close by. So I was concerned about safety, but I thought it would be best for both of us to have law enforcement close by.
And you had not communicated with John in the past about custody exchanges, correct?
Correct. Everything was third party.
So this was the first time in years you had confirmed an exchange with him? And you don't find that suspicious at all?
That's because it had just been ordered by the judge that we communicate directly.
Ma'am, that was ordered in December, 2 months earlier.
But I hadn't had to communicate with him until that exchange.
Continuing with your interview with Detective Crane the night of February 5th, he asked you, did you think this was going to happen tonight in any way? And you said no, but I questioned if it could. Do you remember telling him that?
Yes.
So you had concerns about that happening that night?
I was worried that I assumed, there was part of me that thought John might not show up. That was basically what I thought. Plus, I questioned if CPS would step in potentially. That was my other thought. Because they were talking about stepping in within 3 hours.
Let me ask you again. I think we may have a misunderstanding. Detective Crane was asking you about your father killing John when he asked you that. Did you think this was going to happen tonight in any way? And you said no, but I questioned if it could. You remember telling him that?
No, I don't remember anything about that.
All right. You have that clip ready?
Oh, get it ready.
Let's listen to what you told Detective Crane.
Did you think this was going to happen tonight in any way?
No, but I questioned if it could.
So do you agree now you did tell him that?
Well, I hear it, so I mean, I recognize it.
That was your voice.
Yeah, it was my voice, and it's on there.
You also added, my dad talks really big like he thinks he thought he was somebody who could, I know that it was possible, was how you ended it. You knew it was possible.
But I didn't think it was possible that night or ever. I mean,
That's what you told Detective Crane, was that you thought it was possible that night.
I didn't say that night. If I had thought it was possible that night, I would have made a phone call. I honestly would have. If I could have prevented what happened, both to the Mast family and my own family, I would have. I would have made a phone call. It was a snowball effect that harmed both families, both the Mast family and my own family. We've all suffered.
All right, let's. The next one. Well, let's go ahead and play it. Let's play the next portion of your interview with Detective Crane.
My dad talks really big. Like, he thinks he thought he was somebody who could, I mean, I know that it was possible.
Now, that was in response to Detective Crane asking you if it could happen that night.
Do you have his comments on it?
Oh, I've got better than that. He just testified to it 2 hours ago.
What did he say again?
He asked you if you knew that your father could do this that night, and that's the answer you gave that we just listened to. Do you deny that?
Do I deny that?
That you said that?
I said that? Detective Crane said what in response to that?
I'll move on. In fact, you yourself started thinking about killing John that day, correct?
Oh, absolutely not. Never. I am not capable of killing.
You have that ready?
Just about there.
This is a portion of your interview with Detective Crane, same night, same interview.
Made those
I'm gonna kill him, I wanna
statements.
kill him, I wish he was
I
dead.
never once made those statements.
Okay. Yeah, he didn't say
The
that.
first time I've ever even been like, I'm about there, was today at the courthouse. There was that sheriff, and he's like, well, we have basically used the word for, there's a way to handle it. And I was like, I'm about there.
I said I'm about there, but I never said I was there.
But you knew
I've never been there before, ever.
But you knew the sheriff that day was alluding to, there's a way to handle this. He meant getting rid of the guy.
No, he was talking about safe exchange.
And you said, I'm about there.
And I'm not there. I've never been there. If I was ever there, I would probably make a phone call or go get help for it. Because I like I said, I'm not someone who believes.
And
I'm not someone who believes in that.
you let your father leave your apartment knowing full well he was not making good decisions that day, correct?
What decisions had he made previous to that were bad?
Did you think he was thinking clearly all day?
I didn't think he was thinking clearly, but I didn't think that he made any decisions that would have made me believe he would go out and shoot someone. There was nothing that led up to that would have made me think he would have shot someone. It was his typical diabetes and being a little blurry. Nothing out of the normal for being an aging father.
I'm going to show you page 81 of your deposition. And you said, and like I said, my dad was not totally with it that day.
Correct.
So his decision making wasn't the greatest.
Absolutely, just like many times with a father that's 72 years old. But that doesn't mean that I needed to pick up the phone and say, hey, he's going to go kill someone. I had no knowledge that he was going to do what he did.
But you didn't really care because as you walked back in your apartment, you thought, I don't care what happens.
No, I would, if
That's
I
what
would
you
have known,
testified.
if I would have known that he was going to go do what he was going to do, there would have been a phone call made. 100% there would have been a phone call made.
All right, I want to go back to this email that you sent to John. You didn't warn him about your dad coming to Rosar's, correct?
I didn't know he was going to Rosar's. I thought he was going to go fix the brakes.
So that's a no. You didn't warn him about him going to Rosar's?
Why would I warn him if I didn't know where he was going? When he left my apartment, my responsibility was to my children. I was busy getting them ready for a visitation.
You didn't warn him that your dad had talked about following him, correct?
I didn't know when he left my apartment what he was doing. I didn't need to warn him. He was off doing his own thing at that point.
Did you hear my question? My question for you is, you didn't warn him that your dad had talked about following him. You've already testified your dad talked about that day.
No, I did not warn him of anything that I didn't know he was going to go do.
You didn't warn him that your dad was now driving the Suburban, correct?
I didn't need to warn him he was driving the Suburban. He was going to do a brake job.
Ma'am, these are yes or no questions. You didn't warn him that your dad was driving your Suburban, correct?
No, I did not warn him.
You didn't notify him that you would be in a different car, correct?
No, I generally drove that car or the Suburban.
You didn't warn him that your dad was extremely angry and carrying a gun, correct?
My dad, can you repeat that?
You didn't warn him in that email that your dad was extremely angry and carrying a gun.
No, I did not.
And finally, you didn't warn John that your dad that day had said something about killing John. You didn't warn him of that, correct?
No, I did not warn him of that.
And you testified at your dad's trial that you arrived right at 6 p.m., correct?
Correct.
And you knew your father had arrived earlier than that, correct?
Correct.
You watched your father get in the Suburban and drive off, correct?
Correct.
And that didn't cause you any concern, correct?
Nope, none whatsoever.
Even though he was taking a gun with him.
He always had a gun. He lives in Idaho. 50% of people will carry a gun.
Well, we've established you know and always know that he always has a gun on him. My question for you is, it didn't cause any concern that he was leaving and had that gun with him?
No, that was typical for my dad. He was a hunter safety instructor.
Your father told Detective Crane he took his gun out of the white car and put it in the Suburban. He put it in the
Yes.
passenger seat,
He would
correct?
never leave a gun with the children in
All
a
right.
white car.
And you were right there the entire time he did that.
Yes, I would have been really upset if he would have left the gun with me. Like I said, I don't want the gun with me. I don't really want guns around Zane and
So you
Shira.
were outside by the Suburban and you went to say goodbye to him, and that's when he was talking about and telling you he was going to go follow John.
Can you repeat that?
When you were outside by the Suburban saying bye to your dad, that's when he said he was going to go follow John.
He didn't say specifically he was going to follow John. He said he would potentially follow John or go fix the brakes. And I thought I talked him out of following John and just going to fix the brakes. The last I knew, he was going to go fix the brakes. That was the last I knew.
I'm going to show you page 94 of your deposition. I was asking you, or actually Mr. Miller was asking you if you were inside your apartment or outside your apartment. And you said, no, I was outside by his Suburban. I went to say goodbye. And that's when he started talking about the brake job and I have to go follow John. Those were your words.
Yes.
So you watch him transfer a firearm from a white car to the Suburban. He tells you he's going to go follow John, and that causes you zero concern.
But I did think I had talked him out of it by now. I really had.
He then hands you the car keys for the white car, correct?
Correct.
You watch him get in the Suburban and drive away.
I did. But I did believe that I had talked him out of it because there's other stuff in that deposition as well that talks about me having a conversation with him where I tried to talk him out of it. That's not the only thing in that deposition.
And after everything he had said, his state of mind, being upset, you're never going to have to worry about him again, transfers the gun over and leaves. You don't think something's going to happen.
I don't think something's going to happen. I thought the last thing he was going to do was go fix the brakes, and that was what I thought was going to happen.
But really, you didn't care.
No, I cared a lot.
Well, the last thing you thought, these are your own words from your deposition, was when he drove off, I watched him, I walked back in, and I thought, I don't care what happens.
I didn't care if he was going to go fix brakes. I didn't care about the brake parts or whether he was going to take it to my brother's shop or whether he was going to take it to his shop, or those were the things I meant by I didn't care. But did I care that he was going to go shoot somebody? Absolutely. If I would have known he was going to go shoot somebody, that I would have cared about. Those are the things I would have cared about.
You mentioned a safe exchange
Correct.
earlier in your testimony.
Yes.
That was something that a sheriff's deputy had offered you. I guess that's to have like a standby.
Yes, I at the courthouse, that was the last thing they told me. They said that they wouldn't be able to award the protection order potentially until Monday, but that they would be willing to offer standby law enforcement at the First Cinema Center. And the last I recall, I told them yes to that.
But your father was standing right there with you, and he told them, no, forget it, correct?
And I said I would still like it.
Because he didn't want law enforcement there.
I have no idea what he wanted or didn't want.
But you don't deny that your father told them no, forget it.
He did tell them no. He said, forget it. You guys are not doing anything, or something to that effect.
That email, Plaintiff's Exhibit 2, that you sent, this is the email exchange between you and John Mast. Did you share that email with anybody?
What email are we talking about?
Let me show you. This is Plaintiff's Exhibit 2.
I don't know if I shared it with anybody or not.
But you
I
didn't
really don't.
You didn't talk about this email with your dad or your mom?
I have no idea if I talked with anybody or not about it.
Just no idea.
I have no idea.
About halfway down, do you see where it says, I will be at the end close to the library drop-off box? I will be in Rosar's parking lot a few minutes before 6 p.m. tonight. I will be at the end close to the library drop-off box.
I actually don't. I'm having a hard time reading it from this angle, I think.
Oh, here.
Yeah, that would be very helpful. Thank you so much.
Right there in the middle.
Close to the library drop box. Yes, I see that. Thank you very much.
So you understood that's where you were supposed to go?
I did, and it was funny because I had the same thought that that would be a good spot to drop the children off as well.
But,
I mentioned that.
I mean, the parking lot's kind of large, so he's kind of telling you the area to
Yes,
go to.
the correct spot to go to.
Down at the end.
Correct.
Right. Are you aware that that's exactly where your dad drove to kill John?
I am aware, what I was aware of when I first went there was that both their vehicles were there when I first pulled up.
How would your father know where to go unless you told him exactly where to go?
I have no idea.
Just a total lucky guess on his part.
I have no idea.
Because remember, he says he got there before John. So it's not like he pulled in and saw John and said, oh, I need to go over here. He went and laid in wait. And he went exactly to where John told you he would be in the email to you.
I don't know if I shared the email or I didn't share the email or how it all worked. All I know is it happened and it was a very unfortunate thing.
When your dad shot John Mast, the kids were with you, correct?
Correct.
They weren't in any danger from John, correct?
Correct.
When he shot and killed John, you and the kids were not in the Rosar's parking lot.
No, but we were there right afterwards.
When he killed John, the kids were not with John.
No, but we pulled in and they saw more than they should have. Unfortunately.
And I guess your position is you took them to Rosar's at 6 o'clock because that was the time for the visitation exchange.
Absolutely.
And not because you had to make sure your alibi was okay. Because if you didn't show up, that would definitely be suspicious.
If I would have known that there would be a shooting, I would have not been there with my kids.
Did you immediately leave?
No, I actually waited there and I didn't know who was shot initially. In fact, I didn't know until way into it at the police department.
You sat there for over 30 minutes, correct?
I was there. I kept trying to ask law enforcement officers who was shot and no one would tell me.
So you knew there was a shooting there?
I knew there was a shooting because someone told me that someone was murdered. We saw a body down. We saw someone in a police car, but we couldn't identify who it was.
And the we is you had your kids with
me and the kids and a Nez Perce tribal law enforcement officer who stood with us.
And you had the kids sit there with you for 30 minutes at that scene when there had just been a shooting.
We were not allowed to leave, is what we were told.
And they saw the body on the
Yeah.
Do they know now that was their father?
Yeah. Zane knows that.
Well, I'm sure Shira does too.
We've had a lot of counseling, me and the kids have, over all this. All three of us.
So when your dad killed John, you were not present, correct?
Correct.
When he killed John, John was not abusing the kids, correct?
Correct.
He wasn't abusing you either, correct?
No.
When he killed John, John was not threatening you, correct?
No.
And you and the kids did not have any contact with John at the Rosar's parking lot?
No, we did not.
So he was not a threat of any kind to anybody and was completely unarmed when your father did this?
That is correct.
Oh, 1 second, Judge, I'm sorry.
Take your time.
Did you see Betty Troyer in the parking lot that night?
I saw her once. She was actually running at me at one point and cussing and yelling and screaming, which
Okay.
I understand that.
So you knew who was shot then?
I didn't know who was shot and actually. I guessed it, but no one would confirm.
Your Honor, I'll pass the witness.
Thank you. Mr. Brashier, do you have any questions for Ms.
No,
Brashier? Okay. Ms. Brashier Mast, I'm going to let you sit right there. This is your opportunity to respond to the questions that were asked. It's essentially your cross-examination of
Okay.
yourself. I'm going to ask you to speak clearly. In the event that there is any kind of an objection made, I need you to stop speaking so that we can clear that up. So with that, I'll allow you to proceed.
Okay. So, initially, in response to the video that was originally shown of the statement made where I didn't recall the original exhibit on Detective Crane's statement. One thing to keep in mind is that when I arrived on that scene, there was a lot of trauma. Our whole family, me and my kids, were on that scene for 30 minutes, and then I went into an interview room for hours and didn't know who was, I somewhat guessed it was probably John, but I wasn't sure who it was. I kept asking if it was my dad, if it was John, who it was, and I didn't know. And so that made it really difficult. So there's a lot of trauma, and it's hard to sometimes remember exactly what all happened that night. It's not easy. There's been a lot of, like I said, a lot of counseling associated with it, both for me and my kids. And then, so there's that. I just wanted to have that said. In response to driving the Suburban, I didn't always drive the Suburban. Sometimes I drove a white car. Sometimes I drove with my sister in her vehicle. Sometimes I drove with another brother. Sometimes I even took the transit. So it's not accurate that I always drove in the Suburban. The other factor is that at the apartment when my dad gave me that hug and left, I didn't know that he was going to go to Rosar's. I think I said that a few times. I didn't know in the email or phone call or whatever it was that he was, well, I should rephrase that. I didn't know in the email that I didn't share that email to my knowledge with my dad. I don't know if I shared it. I don't know how that worked. I may have, I may not have. I don't know why or how he got to Rosar's by the mailbox. He may have pulled in, I mean, I don't know how his mind worked. But I'm good now.
Anything else that you'd like to say?
Nothing else.
All right. Mr. Hickey, any redirect on that?
I don't think so, Your Honor.
All right.
Thank you.
Ms. Brashier, Mast, you may take your seat at council table. Thank you very much. Mr. Hickey or Mr. Miller, you may call your next witness.
Your Honor, could we take a brief recess?
We may. How much time do you think you need?
10 minutes.
10 minutes.
10 minutes? Let's go ahead and do that. Ladies and gentlemen, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinions as to the merits of the case. Okay, we'll go ahead and be seated. All right. And Ms. Brashier, Mast, you have a question?
I'm just wondering who the next witness that will be called.
We will find out here shortly.
Judge, that's why I asked for the recess is, we only have one witness left that we'd like to call. I know we've got some usable time in the day, so I feel bad of asking this, but I wonder if we can recess for the day simply because our final witness is going to require more technical stuff like I was doing today, and I want to make sure it's ready to go.
If we do that, and if we start at 8:30, how long do you think your final witness is going to take?
I would say no more than an hour.
Okay, so we can probably be into the defendant's case by 9:30 or 10?
I would think so.
Okay. Who is going to be your final witness?
James Brashier.
James Brashier, okay. So why don't we do that? I think that sounds like a good plan. I think tomorrow we need to be in a position to talk some more about jury instructions. What I will do is this evening I'm going to be working on some instructions, so I will look at a draft in terms of the things that we've been talking about. Again, I think we need to be prepared to come and talk about claim preclusion for purposes of I've got an admitted exhibit of a judgment and conviction for a voluntary manslaughter in this particular case. I think there are issues of claim preclusion that we need to discuss and how that impacts, number one, the jury instructions that I need to give to the jury, how that impacts how they should play out. So I'm going to ask you to be prepared to maybe visit about that.
Very good.
Do we want to bring the jury back at 9 and then we can meet about 8:15 and that gives us 45 minutes or so to maybe talk about some of these things? Would that?
I think that's a good idea.
Would that save us some additional time?
I think it probably would.
Okay.
It would certainly save the jury being excused more often.
Okay. Why don't we do that then? Ms. Brashier, Mast, any problem with that?
No,
Mr. Brashier, any problem with that? Okay, let's go ahead then and we'll bring the jury back. I'm going to let them know. I'm told that there is one final witness that's going to require some setup. And we want to not waste their time this evening, and we'll bring them back tomorrow in the morning, but we anticipate we're moving ahead of schedule. Is that a fair?
I think so. That's
I think
fair.
that's fair, Jim.
I think they'll appreciate hearing that we're ahead of schedule. And then Ms. Brashier, Mast, Mr. Brashier, once the plaintiff rests their case, what I'm going to do is to turn the time over to you for the presentation of your evidence, and I expect that that's going to be tomorrow morning. So I'm going to have you have your witnesses ready to go so that we can just move right into it, okay?
Yes, sir.
All right, thank you. Please rise for the jury.
Somebody in the back.
Okay. We didn't tell them it was going to be 10 minutes, so there is that. This is an example of me I guess, over-promising and under-delivering. I don't know if that's, I warned you about that. Sounds like you're ready. All right. All right. Thank you. You can be seated all. Again, we're back on the record in Mast v. Brashier, Nez Perce County case CV 35-23-195. The jury has been returned. They appear to me to be seated and properly seated. Will the parties stipulate that the jury is back and seated appropriately?
Yes, Your Honor.
All right, very good. Okay, ladies and gentlemen of the jury, I've got good news for you. The good news is we're ahead of schedule. And the other good news is we are going to break for the day in order to allow the attorneys and the parties and me to work some things out and for them to prepare for the next witness. And so I know we started today at 8:30. I think tomorrow we're going to start at 9 o'clock because that's going to give me some additional time tomorrow to meet with the attorneys and the parties to work through some things that I think is going to save us some time ultimately when we start to prepare to send the case to you. So I'm going to, again, excuse you for the evening. Appreciate your patience and attention today. I'm going to leave you with this instruction yet again. Members of the jury, I remind you that you're not to discuss this case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. For that, again, appreciate your time and attention today. And by the way, thank you for being here on time. I want you to know we try to respect your time as much as we can. So you being here on time has helped us kind of get things going. So thank you for that. I wish you a good evening, and we'll see you tomorrow at 9 o'clock. Thank you. Please rise for the jury. All right. So before we go off the record, I think what we'll do tomorrow, go ahead and be seated. Thank you. I think what we'll do tomorrow, because the jury is going to be reconvening and coming through courtroom 3, when we meet tomorrow at 8:15, let's plan to meet in courtroom 2. That way we can do so without worry about disrupting the jury. And again, that'll be just take up any pretrial issues and we can touch base and see where we're at. I wish you all a good evening. Appreciate your attention today. Anything else that we need to take up this evening before we recess?
I don't think so, Judge.
Okay, very good. We'll be in recess. Thank you. We'll see you tomorrow morning.
Hey guys, so that's going to be the end for today. We will be back in the morning. I'm guessing you just heard from Judge Monson. I'll reserve any comments till later. Thank you all for supporting. We'll be back. There's already a link up if you go to the Dad Talk Today YouTube page. It's the John Mast Wrongful Death Trial, Day 3. If we can go back and get a little rest and everything and kind of, calm down for a minute, I'll do some stuff from my personal Facebook tonight. And thank you everybody for showing up and your support, and see you tomorrow. Thanks guys.